Good morning. The first case to come before the court is State of Ohio v. Geovanni, Rosa DeJesus. Did I say that correctly?
I think so.
Very well. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, counsel, please let me know, as I'll be keeping track of the time and try to alert you when you go into your rebuttal time. The arguments are being recorded, so if you would please stay behind the podium and keep your voices up. You should not use the names of victims or minors or children should that be relevant to your argument. You can refer to those folks by initials or terms that are general, like the child. We have read your briefs. We're ready to proceed when you are. So, counsel, I would just ask you, would you like to reserve time for rebuttal?
Yes, 5 minutes, please.
Very, very well. Then please, both of you, when you come to the podium, introduce yourselves, and we're ready when you are.
Thank you, Your Honor. May it please the court, my name is Stephen Hanadel. I represent the appellant Geovanni Rosa DeJesus. This case has, two issues. First is that the trial court allowed the accusing witness to have a dog present with her, in the courtroom, in full view of the jury. And this has come up before in this court, but I think the problem with this court's prior case law is not so much how the court decided it, it's just that it's how it was argued before the court and what issues were raised or not raised. And so the case law, I think, is rather incomplete and undeveloped, and I think there needs to be more development in the case law. In fact, that's what former Judge Carla Moore talked about in the Hazenjager case.
Could I stop you just for a second?
Yes.
I want to make sure that you started out with having a dog in full view of the jury. How do we know that?
I'm surmising that from the transcript. So when the accusing witness was called to testify, there was no recess at all to excuse the jury. Otherwise, you would see that in the transcript that the jury is excused, and then they get the witness set up on the witness stand, and then bring the jury back in. And there was nothing. There's no indication in the transcript that took place.
How do we know the dog wasn't already there in the witness stand?
Well, the accusing witness, she wasn't the first witness to testify. So I believe her father testified first. So she was not the first person to testify. So and based on the discussion that occurred before the trial began, the victim advocate from the prosecutor's office gave brief testimony about the benefits of the dog, but only spoke in the generality. The state presented no evidence that this particular witness, AT, needed that dog by her side in order to testify truthfully and reliably in trial. And so the state presented no evidence to that effect. The victim advocate more or less just gave general testimony about, the dog can help provide comfort for the witness in the general sense, but as far as the accusing witness in this case, there was no evidence introduced as to why AT herself in particular needed the dog by her side in the trial. And so ultimately, the visuals are important in a courtroom, because that's why a defendant is entitled to, who is otherwise in jail awaiting trial, that's why a defendant is entitled to wear civilian clothes in trial, because that visual does affect the way the jury views the case. And so before the accusing witness takes the stand and the jury sees the dog by the witness, that presumption that the witness is in fact a victim, it starts before there's been any evidence introduced, before any evidence is established to prove whether that witness is in fact a victim. So, we cannot allow that presumption and prejudice to occur. And and I'm not trying to take away from the therapeutic benefits of dogs. I'm a dog lover myself, but there are ways where the accusing witness can have the comfort of the dog, let's say before she testified. Here in Lorain County, right outside the courtroom here, we have private conference rooms. she can hang out in there with the victim advocate, with the dog, until it's her time to come into the courtroom and testify. Or if there is a way to shield the dog from the view of the jury, reliably assuming that the dog is well trained enough, which again, that has to be established before trial, the dog is well trained enough to not make any disturbances, and therefore the jury doesn't see the dog. I think it's going to kind of sort of depend on case by case in terms of the courtroom facilities. Now here, if you see the witness stand is fairly big enough, so if there's a way to shield the dog from the jury, then okay. But the problem in this case too is that the jury was not recessed to leave the courtroom as they bring the dog in with the witness to the witness stand, because as we see, the courtroom we're in right now looks very much alike the courtrooms on the 6th floor and the 7th floor too. And I believe this trial took place on the 7th. No, I think it was on the 6th floor here, so Judge Rothgary's courtroom. So but the courtrooms all look similar here, and so the only way that there's no way for the dog to get to the witness stand. There's no way to shield that from the jury unless they're not in the courtroom. So, and I think Judge Moore brought up these issues in the Hazenyeager case where she warned that there needs to be a standard established, and so that we balance the rights of the accused, and so that the accused is not unduly prejudiced by the visuals in the courtroom, and because jurors can't help themselves. I mean, I can tell you just from my own experience of almost making it onto a federal jury a couple years ago, when you get paraded into that courtroom, and you can't help but to form thoughts when you start seeing the people that are in there. So when jurors see that dog, there's inevitably going to be people on that jury who are going to, it's going to affect their emotions and their feelings, and they're going to start thinking, oh my gosh, that poor girl. She's obviously been through some trauma, and that affects whether they're going to believe her or not.
And you said there's no jury instructions on the use of the dog.
There were no jury instructions at all, and I believe that the trial counsel did propose an instruction, but the trial court rejected it, and also there's some issues I think with trial counsel with the way he handled the initial hearing with the victim advocate on the stand. He filed a written objection that brought up a lot of good issues, but then he didn't pursue all those issues in questioning the victim advocate, and that's where I argue ineffective assistance of counsel as well, because I don't think there's any reasonably sound strategy to you file issues in writing, you raise issues in writing, but then not pursue it in questioning when the judge holds a hearing. So
could it be argued that this is harmless error because the jury ultimately didn't believe the alleged victim on a number of issues? There's a lot of not guilties on the rape.
I don't think it can be harmless. And I know what you're saying, as far as giving the evidence involved, but it's not harmless because there's got to be a firm.
It sounds like the
line established. I think it's akin to, let's say, a defendant who's being made to wear a jail outfit while standing trial. And so the visuals are important. Jurors can't help themselves when they're in a courtroom and they're looking around. They see the way people handle themselves, see the way people are dressed. They're humans. We can't help to form perceptions by what we see and what we hear. And so, which is why it is firmly established that a defendant has the right to wear civilian clothes.
And your client made some admissions to the police as well.
He did talk to the police.
And it sounds like the jury found him guilty. The things he described in the confession were the things the jury found him guilty of.
The confession was only about the GSI. He denied raping the child, so he did admit touching her inappropriately. So that's true, but he denied the rape allegations, and ultimately the jury found him not guilty of most of the rape charges. They only found him guilty of one, which then leads me to my next issue about the sentencing. I don't know if there's any want to engage in any discussion about the dog, but in regards to the sentencing, the judge then imposed life without parole. And despite the fact that he was acquitted, I believe, I think there were 5 rape counts, and he was acquitted on 4 of them, and he was only convicted of 1. He was convicted of the 3 GSI, which he pretty much admitted to in his interview with the police. So, given that, the judge had an option to impose a life sentence with the possibility of parole, but instead he went straight to life without parole. And this then also brings up the issue whether that sentence can be reviewed. I think it can be reviewed under Revised Code Section 295302, which is the general right to appeal. I know there's been cases in the Ohio Supreme Court lately. This has been a hot topic as of late in the Ohio Supreme Court. The Ohio Supreme Court has been, in like State versus Jones, has been discussing 2953.08, which is a more specific statute about what can be reviewed or not reviewed on a sentence. And the Supreme Court held in State versus Jones, and then 4 days later they came out with State versus Patrick. So you got to read these cases kind of together because they're 4 days apart. But what happened in Jones is that the 8th District reviewed a sentence under whether it complied with 292911 under the dictates of 2953.08, and the Ohio Supreme Court said, no, you cannot do that. That's the wrong, that statute doesn't apply to do that. They didn't go any further as to whether any other statutes could allow a review of 292911, probably because that wasn't argued. So, and the court's not going to venture into issues that are not raised before them. But in Patrick, the Ohio Supreme Court did say that, well, yes, 295302 is the general right to appeal. The final order is the sentence.
And counsel, I want to let you know you are moving into rebuttal time.
Okay. And I'll just be real brief here. The right to, that 295302 is the general right to appeal the sentence. So basically, anything that's not enumerated in 295308 is fair game under 295302. And that includes the statute that I'm arguing that the sentence is unjust under, 292911, about the balance of burdening government resources versus achieving effective rehabilitation. And the trial court made no effort to assess whether Mr. Rosa DeJesus could someday be rehabilitated to the extent where he could be allowed out in society again, and decided that he didn't want to trust the parole system to make that assessment or evaluation at a later time. And the fact that there was no effort to make that assessment, just decided, you know what, I'm just going to throw him in prison for life without parole, but then now we, the taxpayers, are going to have to pay for his nursing home care when he's an old man. So that balancing test was not done, that assessment was not done by the trial court. That's what 292911 calls for. So I'll reserve the remainder of my time.
Very well, you'll have 3 minutes and 45 seconds when you get to rebuttal. Thank you.
Good morning, judges. I'm Mark Cozy here on behalf of the State of Ohio, Lorain County Prosecutor's Office, J.D. Tomlinson. Looking at the first assignment of error, whether or not the trial court abuses discretion in allowing the dog to sit with the victim, the appellant has made a point that the state provided no evidence. I would take issue with that, is that there were filings in this matter. He even mentions trial counsel's filing, but specifically the state's filing in that. And there's 3 points of note in there, whereas AT, the 13-year-old victim, she stated that she was familiar with Drake, the facility dog, she appeared more relaxed with him, and she indicated she'd be more comfortable testifying along with Drake being present. I would say those arguments alone go to what appellant is trying to argue, or trying to create a more standard by looking at Hastings-Jaeger, specifically Judge Carla Moore's concurrence, where she wants to balance the reliability and the reliability of the testimony and the accommodation versus the prejudice. And looking at here, the state did that. The state went above and beyond what this court has upheld previously in Jacobs, the majority opinion in Hastings-Jaeger, and Williams. The state here did present the evidence of the benefits of, on both medical and scientific journals, of having a child testify with a dog, especially with child sex victims. Additionally, the court was made aware of Hastings-Jaeger also because they were presented with the case, and so I believe that the court did not abuse its discretion. I understand the court did give a limited reasoning, challenging whether or not the expert report was done as trial counsel brought up about requesting a Daubert hearing, but I think armed with the state's evidence, the testimony that came out at the hearing, and the prior case law provided to the court from Hasenjager, Jacobs, and Williams, that this court did not make an arbitrary, unreasonable, or rash decision that was within their discretion and was appropriate.
Counsel, before you move on, do you agree that there would have been no way for the dog to enter the courtroom and be at the witness stand without the jury seeing him?
So this is, as appellate counsel said, this is 2 courtrooms over, it's the same pretty much design, 602. So I think also there was an accompanying test to motion that the victim advocate would sit there with the dog. So I don't know, I don't, based on the record, there's no break. We don't know what actually happened if the dog was paraded. There's no mention of it making and barking. But typically, having done hearings with the dog present, the dog sits underneath the table there, right there, it's the same design, and it's not visible the whole time, but the dog would be brought in. It wears a little vest, Drake's a little blonde older dog, and then the victim advocate would be sitting in between where Kit and the victim stands. So,
And that's not laid out in the record, but,
not present in the record.
but you agree there's no recess taken?
That's
fine.
Just the scripture. Looking to the assignment error 2 based on ineffective assistance of counsel, would say that trial counsel did file an objection. I mean, what the basis is that the cross-examination was not extensive enough to bring, that ultimately prejudiced the appellant because the dog was present during the testimony. I would say that cross-examination is just mere trial strategy, doesn't rise to the level of prejudice. If it did get to prejudice, looking at appellant's arguments, they appear to be just speculating on if Anna Evans, the victim advocate, had testified, would she have been able to say scientifically whether or not there's evidence that a child victim testifies better? Once again, that's just speculation. Additionally, he states that it would have helped the court be more informed on Hasenjager, and specifically Judge Carla Moore's concurrence. As stated earlier, the court was presented with Hasenjager and the concurrence. So I don't think the court was less informed, or this cross-examination would have done this. I don't believe the second assignment of error has merit. With regards to assignment error 3, I believe the appellate counsel did today correctly state that you have Jones and you have Patrick. And in Patrick, specifically, the Ohio Supreme Court recognized that 295302 can be a basis to form an appeal. I think that note in there was specifically, if you read it closely at Patrick, they were arguing with the state where the state said you can only appeal a sentence under 295308, and if you read clear, they're saying that's not the only basis to appeal a felony sentence. You have 295302. I do believe 295302 is a general felony sentencing right to appeal statute. Looking at this court, how they have viewed State v. Knight and State v. McKnight, which has come after Jones and Patrick, specifically looking at 295308G2, the basis to review a sentence, this court has upheld that challenges or issues with findings under 292911 and 292912 are not the basis to challenge the sentence. With that, thank you.
Thank you very much.
Thank you. As regards to the sentencing, as to this court's case law that, in the last couple of years since Jones and Patrick, I think the issue with those cases is that the analysis was not full enough. Again, not because this court was, doing anything deficient. I just think that the issues weren't fully raised before this court like they've been raised here. And so that's why with the McKnight case in Knight, that, they don't quite have the applicability. I think this court's got to go further. And again, I just don't think the issues of 295302 were fully raised and argued in those cases. And so ultimately, what I think the Supreme Court made very clear in Patrick is that 295302 does present its own right of appeal. It's a general statute. 295308 is a specific statute where it operates to restrict what can be appealed and not appealed based on what's enumerated in 295308. Well, 292911 is not barred from review under 295308, but it goes both, the silence goes both ways. And so ultimately, 295308 does not operate to apply to review 292911, and that's what the Ohio Supreme Court held in Jones, because basically what the Ohio Supreme Court said in Jones was that the 8th District just used the wrong statute. But they didn't go any further because nobody brought up 295302 as another method or means to review 292911. I'm doing it here. So I do think that 292911 can be reviewed under 295302. Therefore, I think the propriety of the trial court sentence of life without parole can be reviewed by this court, and I think this court should at least remand on that basis for the trial court at least to perform an assessment as to whether Mr. Rosa DeJesus can be rehabilitated someday. You know, it can, you know, at least trust the parole system to make that assessment at some point down the road. And, you know, and again, he still could spend the rest of his life in prison if the parole board feels that he's not suitable to rejoin society. But I think the issues in this case do present that, you know, because this wasn't developed, I'm speculating in here, but he may have a sexual addiction of some sort, and perhaps, you know, the question is, can that be treated? We don't know, and that's something I think the trial court should have performed an assessment on to determine whether, you know, is he a candidate, should he be a candidate for parole someday versus never at all, never again. And especially because to my knowledge, I don't think he had a prior record as far as I know. And then just going back to the issue with the dog, again, the crux of this is all about the view of the jury. And, you know, given the facilities here in Lorain County, there's nothing wrong with the accusing witness being with the dog outside the courtroom, in a private conference room, before she testifies, or even after she testifies, or if there's a recess while she's testifying. I have no issue with that at all. It's all about, you know, what is the jury seeing? And because you don't want the jury to develop any prejudice based on, you know, the visuals that they see. And because, you know, let's face it, people like dogs. I think, you know, people accept that that dogs do offer therapeutic benefits to others, and you just don't want the jury to develop that presumption that the accusing witness has in fact been victimized or traumatized before there's any such evidence establishing that at the trial.
Okay, counsel, thank you. Your time is up.
Thank you.
Appreciate it. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. Clerk, of course, will mail a copy of the decision to you on the day it's released, and the opinion